stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Static. And Mark, I have a very happy news to announce, and that's our case, Mexican Gulf Fishing Company versus the United States Department of Commerce. The Fifth Circuit has come down with its opinion, and it has said that the final rule tracking all the charter boat fishermen in the Gulf is unconstitutional, likely under the Fourth Amendment, but they mainly said that there were huge violations of APA. And here's the line that I think covered what they're about to do. It's the start of this. We conclude that in promulgating this regulation, the government committed multiple independent Administrative Procedure Act violations and very likely violated the Fourth Amendment. We are therefore compelled to hold unlawful and set aside the regulation, reverse the judgment of the district court, and render judgment for the appellants.
Yay!
So, yeah, exactly.
Congratulations, John. That's a big victory. That's fantastic.
And this was a class. So we have our named plaintiffs who brought this case and have fought like tooth and nail all the way, but they were granted class certification. So it's for everybody who has a charter boat license in the Gulf of Mexico.
And this is over 1,000 people that you've helped here, John, with this result. John argued this case at the Fifth Circuit. And for anybody who wants to hear what a masterful oral argument sounds like, go look up John's oral argument in this case. It was you might think oral arguments boring, but if you follow this program, you probably like law enough that you're going to think this is a very entertaining oral argument. And John was encouraged by the judges to sort of play it up a little bit because it was in front of, was it the Texas A&M Law School?
Yeah, it was Texas A&M. It was at Fort Worth, and it was at the law school there. And she had told Judge Elrod actually told an earlier advocate, why don't you explain the fact, because it was about video games, the previous argument. And she thought that the law students would at least know about video games.
And so, the previous argument wasn't quite as entertaining as I think they'd hoped when they selected it. So they thought, well, maybe John's case, maybe he can entertain the audience. And if you know John, it doesn't take much to spur him for the entertainer to come out. And he did a really wonderful job. But John, I in saying that, you also made all the legal arguments you wanted to make. So it wasn't that you were just playing to the crowd. I mean, you obviously reached the judges as well. So
right. And
kudos to you.
They did. And I'll just, before I go into the opinion, I do want to note that there was a split. So it was Judge Richmond, Chief Judge Elrod, and Oldham. And Chief Judge Richmond concurs in the judgment and joins Part 2A, 1A, 2B1, and 3 of the majority opinion. So for some reason, she didn't join 1A, which is just describing what the act is and who the I guess she did join it. Okay, I see. She didn't join 1, and I don't know why, because it's very short and just says what the act is and what it does. I'm like, I can't figure out why she didn't join, but it doesn't matter one way or another. And Judge Oldham concurred, but he said no, we should not rely on Chevron. I'll get to that in the next segment, but I do want to talk about this opinion because I think it's very important for just about every regulated entity to take a look at this. And there are certain tools that the administrative state uses to get away with everything that have really been either blunted or removed in the Fifth Circuit by this opinion, Mark. And I want to point out exactly what was happened here. So the National Marine Fisheries Service and NOAA that are under Commerce, that's why we sued them all, they proposed the regulation, which did a couple of things, and I'll just highlight the ones that we most complained about and were struck down. The whole rule was struck down, but this was what caused the case to be brought. First, you had to buy a VMS device. That's a vehicle monitoring system. Everyone else in the world would call it GPS, but of course, the administrative agencies have to have another name. So I use GPS or VMS, but they had to buy this, and then they had to have it broadcast their whereabouts at all times back to the government every hour. And there was really no reason for it. And the court saw that because these charter boats, they're not always fishing. Sometimes they're touring, and sometimes they're just going to their spot, and they don't want their spot where they know where there's fish. This is like the big thing in the Gulf. Like every fisherman doesn't want other fishermen to know his spot. And I think that that's driving a lot of why people are so mad at this, besides the Fourth Amendment and warrant requirements and all the rest. That's a trade secret of sorts, right? It is. And I think it goes more than that. I mean, all these people who spend time on the sea or on the rivers of this country and who are fishermen are like, no, I don't want to tell people where it is. Anyway, it's like part of the industry or part of the pastime, I think.
Yeah, the local knowledge too.
Exactly. And it is a trade secret. And that came back again and again. But the other thing is that you also had to tell them that, so the agency did not say what they were going to ask you, what other information they were going to ask you. They said, we will also ask for other socioeconomic information. But when the rule came out, the socioeconomic information was the following: how many passengers you have on your boat, what you charge them, what you pay for gasoline, all these other trade secrets and things that the people the charter boat fishermen were very nervous about. That what are they going to use this for? Are my competitors going to be able to see it? Is the IRS going to check how many passengers I have and all this? Because they were very nervous that these documents would be misused. But it wasn't in the notice for the rule. We were just talking about notice and comment. Nobody could figure out what the heck this other information was. And as the court pointed out, and we had argued, it's not socioeconomic data. It's straight economic data. It's not like, how many women were on the boat or how many, bricklayers, or there's nothing socioeconomic about it. So they struck that down as well. But I think how they did it is going to be useful in the future, because that
reminds me of that. Was it an insurance commercial where he says, "Useful shot, useful," talking about the Gulf?
Exactly. And so what they were trying to say here, that was that certain things, the Magnuson-Stevenson Act uses the terms necessary and appropriate, that the secretary shall be able to make rules necessary and appropriate to serve the purposes of the act. And they always say, the agencies always say, Mark, that necessary and appropriate means anything goes. We are the judges of necessary and appropriate, not the courts, and not anyone else. We get, and under Chevron, we get wide difference under what's necessary and appropriate to serve the purposes of the Magnuson-Stevenson Act. Well, the Fifth Circuit was having none of it. They say necessary and appropriate is not carte blanche. It's actually limiting, because it has to be necessary and appropriate to something you're doing. And we can't figure out, and they asked the lawyer for the agencies at oral argument, they said, how does this tell you anything about fish? Because other parts of this say report your fish, and we understand fish counting, but we don't understand.
That's happening already before this regulation. Yeah.
Not before this regulation, but as another part of it.
Oh, okay.
Like they talked about it, but for charter boat fisher, this was new.
Oh, no. I thought they were already reporting their fishing. It just wasn't electronic reporting. But when they came back to the dock or something, I thought they had paper reports.
You could be back. Charter boats had not been regulated in this way before.
Okay.
But that they put it in, and they'd had, in other fisheries, they'd had logbooks, and this sort of information had been done that way. But in any event, the key thing here is that they could not figure out how they could say it was necessary and appropriate to counting fish. And they said, so that simply doesn't help you. And then the other thing is the Magnuson-Stevenson Act says that they can require any equipment needed to enforce the Magnuson-Stevenson Act. And the Fifth Circuit said, oh yeah, you can, but this isn't that kind of equipment because you haven't been able to tell us anything this equipment, meaning the GPS device, does to defend the wildlife or the fish or monitor or count anything. So it really, that is big. And I do want to read, Judge Elrod did go to Chevron, did use it. She used the textual arguments I just made that, they don't mean that, those words don't mean what you think they mean. But she also used Chevron, and the logically antecedent question is whether the Magnuson-Stevenson Act authorized NOAA and all the other agencies to issue the GPS tracking requirement. And this question invokes the analytical framework set forth in Chevron. And I won't go through the whole site. Dun, dun, dun. And then she says the familiar framework proceeds in 2 steps. Step 1, we ask whether Congress has directly spoken to the precise question at issue, in which case we must give effect to the unambiguously expressed intent of Congress and reverse an agency's interpretation that fails to conform to the statutory text. And then the other one is if the statute is silent or ambiguous as to the specific issue, we proceed to step 2 and ask whether the agency's answer is based on a permissible construction of the statute. So she uses the Chevron paradigm here, but I do. We'll get to Chevron in the next thing. Welcome back to Administrative Static. And I was just getting to the Chevron footnote, which I think all of our listeners will enjoy, as there's a big fight over Chevron, and we're on one side of it, we want it gone. And many of the federal judiciary have pointed out this same problem, including Judge Oldham in this opinion. But here's what she says about Oldham's concurring opinion. The concurring opinion would jettison the Chevron framework and simply apply the traditional tools of statutory construction to analyze the issues presented. Indeed, the opinion conjures up Chevron as, quote, the Lord Voldemort of administrative law, unquote. He says, to be sure, Chevron has been something of the precedent who must not be named, all hyphens before it, just like left unmentioned by the Supreme Court in 2 recent decisions addressing the reasonableness of agency action. And we know what those are. It's American Hospital Association for Becerra and the other Becerra versus Empire Health, which we've discussed on this program. We darn well thought they'd mention Chevron. And we recognize that the concurring judge and many other distinguished jurors, as well as some less distinguished, see Cargill v. Garland. That's Judge Elrod's own opinion. So she is poking a little fun at the distinguished jurist trope. Have questioned Chevron's consistency with our duty to say what the law is. But lest we not forget, quote, fear of a name increases fear of the thing itself. Quote. And the cite for that is J.K. Rowling, Harry Potter and the Sorcerer's Stone, 1998. We therefore name Chevron and apply its precedent until and unless it's overruled by our highest court. So the first thing she takes on is equipment, and I've already talked about that. And the next thing is she goes on to the necessary appropriate, and I already talked about that. And I really, for all practitioners out there, what they say about necessary appropriate on page 10 and 11 of this is going to come in useful because so many statutes use this language. And there has been so much commentary on necessary and appropriate, necessary or appropriate. It's a big issue. And I think this comes out very well for those who don't want the agencies running roughshod over either procedure or over their powers that have been given by Congress. And this is the thing that really she hit on. In opposition to the costs, and this is another thing, she says that part of the analysis has to be that the benefits exceed the costs. Start with the costs. And she notes the final rule costs people $3,000 plus 40 to 75 months in service fees. And she notes that the charter boat owners don't make a lot of net income. And there's a massive privacy cost imposed in the Fourth Amendment area. The government's following you around. And then she says, what benefits does the government point to in response? Next to nothing. It says that National Marine Fisheries Service is charged with conservation and management of national fisheries, which is always true. But the government fails to connect the GPS tracking requirement with any legitimate conservation purpose. By the government's own telling, the only other purpose served by the requirement is to verify whether a vessel is at the dock and to determine when a fishing trip was taken and the length of the trip. Now, she says the inordinate costs might be necessary if the government truly needed it, but the government already has this information from the other parts of the statute. Indeed, at oral argument, counsel for the government denied any awareness of inaccuracies in charter boat owners' reporting of the same information in accordance with pre-existing reporting requirements. As a result, the government has failed to show that the GPS tracking requirement is necessary and appropriate for the conservation and management of the fishery. And then she goes on about it's more than financial costs. It requires analysis of the cost of constitutionally protected privacy interests. And then she goes on about the APA is that, look, you didn't answer any of the questions about the Constitution. And she said that just because the commentators asked about the Fourth Circuit, the Fourth Amendment, that they just said this was a privacy concern and not a warrant concern. And she called that statement that borders on the incredible. So they've construed this statute to avoid the constitutional problem, meaning they're not going to get to the constitutional issue because they'll just construe the statute as not allowing this sort of thing under these circumstances. And they also reject that charter boat fishing, and this is another important holding of this case. Charter boat fishing is not a closely regulated industry, and that exception has allowed courts to get around the warrant requirements and get around the Fourth Amendment because there are 4 cases out of the Supreme Court that say that liquor sales, firearms dealing, mining, and operation of automobile junkyards have been closely regulated forever, and so they have a lower expectation of privacy. But she says commercial fishing hasn't been determined that. We don't determine that commercial fishing is that at all. But certainly we know for sure that charter boat fishing is not. They didn't even regulate it till the 90s. So I really believe that this is going to be important because the expansion of closely regulated industry theory is a huge danger to liberties for everybody. Because as society grows and regulation becomes more popular, what she's signaling is that doesn't mean it's closely regulated just because you've got to get a license or you have to, they make rules about where you can go fish or anything like that. That doesn't make you closely regulated. The one item that we did not win, the one argument we did not win in this case, really is we felt that the case of Patel, which is a Supreme Court case, had made the requirement for closely regulated that you also had to show it was dangerous because all the other closely regulated industries are dangerous. And she said, nah, I'm not adding that. We're not adding to that. She actually says, and I gotta point out the bad with the good. We now hold the government has the better reading of Patel. So I'm sure my colleague on the other side of the V will be happy about that. I am hoping to get that in the future the Supreme Court will address this and will find dangerousness as an aspect of this. And so then she says it's charter boat fishing. You got to look at the industry very closely with what you're talking about. So I think that also will have huge benefits for litigators in the future. And I'm gonna quickly move to the concurrence, because she has found that they found that it was arbitrary and capricious, this whole rule, and this is the assertion that the government failed to identify this particular concern, meaning Fourth Amendment concern from the public comments borders on the incredible. When a judge says that, they're about to tell you it was arbitrary and capricious. And also because of the costs. They didn't justify the costs, and so that too makes it arbitrary and capricious. And so just a big win all around. And then she found what I mentioned before, that there wasn't fair notice of the other things they were going to track as far as what you turned in. But I want to turn very quickly to Judge Oldham's concurrence, because he says, I join the court except as to invocation of Chevron. That's for two reasons. First, the Supreme Court has directed us to use the traditional tools of statutory interpretation in lieu of Chevron. And that's what he says. Chevron, that's what he says American Hospital Association v. Becerra stands for. So he's saying use statutory tools before Chevron instead of this two-step process, which is good. In two cases just last term, both of which directly implicated Chevron and the reasonableness, vel nom, of an agency's statutory interpretation, the court did not even cite the case. Second, it's unclear how, quote, the Lord Voldemort of administrative law comports with our legal history and tradition. And he's citing Timkovich, who dissented in a 10th Circuit case with that famous line. And so he cites dissents by Thomas and an article at a Yale Law Journal. Accordingly, I use the Supreme Court's instruction and traditional tools of statutory interpretation to hold the GPS tracking requirement violates the Magnuson-Stevenson Act. So this is a big win all across the board. It has a lot of nuggets in it for practitioners and for people who care about liberty. And I want to thank that we had amicus support in this case, and amicus pointed out many of the points that were won here, particularly about the Fourth Amendment. And one of our friends of the court who were also friendly to our position has petitioned the Supreme Court in their case, and that's the Loper-Bright case, which is about, like our relentless case, putting monitors on boats, who pays for it. So there's a lot of good language in here for that case. And I hope it will be, I think there's a reply brief up. I hope it will be cited in the reply brief because they have petitioned the Supreme Court and the government has opposed it. And the government has opposed it, as I said last week on the topic, by saying, Chevron's great and you don't need Chevron. So all of these issues and the Magnuson-Stevenson Act are all flashing together, if you will, all the way up to the Supreme Court. And as we see in this case, whether or not Chevron is alive and how alive it is, some judges like Judge Oldham are actually, he doesn't think it has a lot of vitality. I think he basically thinks that it only has vitality if the statutory tools don't work. And I think his position would be they're always going to work. And that would be a good outcome as well. But of course, the best outcome of all is to get rid of Chevron. So big win. We're very happy. I don't think the government will petition the Supreme Court or do anything about it. I think it's kind of done deal. But we will see, and we'll let you know. See you next week.